The next case on the docket this afternoon is Lentini versus American Southern Home Insurance Company. All right, Mr. Boganoff, you may proceed.
Good afternoon, Your Honors. May it please the Court, my name is John Bogdanoff, and I'm here on behalf of Mr. Lentini. I'd like to reserve 5 minutes, if I may, for rebuttal. The issue presented in this case is very straightforward, and that is whether an automobile insurer, without informed consent or informed written consent of the insured, can create a limitation or a restriction on uninsured motorist coverage contrary to the provisions of the UM statute 627-727 and Supreme Court decisional law applying that statute. Or to be more blunt, who gets to decide the scope of uninsured motorist coverage? Is it the insured or is it the insurer? Florida law seemed to...
Or is it the legislature?
Or is it the legislature? Florida law was pretty clear up until the case of Martin versus St. Paul that it was the insured. The insured got to decide ultimately the scope of the uninsured motorist that he or she wished to have. Martin versus St. Paul, however, the case that we're here to ask you to examine and disagree with, held that in the context of a collector or an antique motor vehicle, that it's the insurer who can determine what level and scope of uninsured motorists.
Did the legislature carve out any exceptions?
The legislature has carved out exceptions in 627-7279. There's 5 of them, but none of them apply or are invoked in this situation. So none of those exceptions would apply here. This is an exception that the insurer created.
Could any of those exceptions have applied had there been written consent? No.
This is an exception, and Martin recognizes that this is not does not fall within those exceptions that are contained in the statute.
So Martin is on point.
Yes.
It's not to be distinguished. They're just wrong is where you're going, right?
Yes.
Okay. Tell me why 9D
9D?
wouldn't apply.
Well, it talks about occupying any vehicle owned by the insured for which uninsured motorist coverage was not purchased. In this case, the decedent was occupying a motorcycle when he was killed. So depending on whether or not that falls within the definition of vehicle, that would not appear to apply. However, even if it did apply in this case, there's no written compliance with the remainder of the statute, which requires an informed written
I know, but that's what I'm asking. If there had been written consent, would any of these exceptions apply? Your position is that, and I haven't looked at this, but your position is that a motorcycle is not a vehicle?
Well, I don't believe, as this was presented in the lower court, that exception was invoked by the insurer, and for the proposition that this.
Well, wouldn't that just be because they didn't get the written consent?
That very well could be that they conceded that they did not comply with the statute.
I'm just asking you so that to get a full view of the statute. Would this exception apply had they gotten the written consent?
I think that's probably an arguable point. He was occupying a motorcycle when he was killed. So I concede that's an arguable point. But
the record demonstrates there was no written consent.
Correct. And the insurer on page 5 of their answer brief acknowledges that there was not compliance with the statute. So yeah, this is right on all fours pretty much with the Martin decision, which created or approved of an exception to UM principles for collector and antique motor vehicles. We believe that case was decided erroneously for several reasons, as we argued in our brief. Among them is the fact that this is, as I think was alluded to, that this is a legislative function, that whether or not there are to be new exceptions to uninsured motorists is a decision for the legislature. It's not a decision for the judiciary. And in fact, in reading Judge Altenburn's
Suggestion that they went beyond the bounds of simply interpreting and they were legislating from the bench?
yes, that in this case there was no
activist judges?
Yes. In this case, what the court did is essentially conclude, it had a two-prong analysis. One prong was that there was decisional law that suggested that coverage was no longer bound to financial responsibility laws. But as we pointed out in our brief, there's several cases, even a Florida Supreme Court case, in the intervening years that says no, uninsured motorist coverage is tied to financial responsibility laws. So that really is not even a point I think that was argued in the answer brief. I think the primary focus is the second analysis that the court engaged in, and that was that there's policy reasons why collector antique insurance policies differ from other types of automobile insurance policies. And the court concluded, based on those differences, that the principles of uninsured motorist law in 627, 727, as well as previous opinions, even from the Florida Supreme Court, don't apply in this context. And we think that not only was that a legislative decision, but that the court relied not on record evidence. There's no indication that the court had before it record evidence that, for instance, premiums would soar if insureds had to be offered uninsured motorist coverage consistent with the statute. There's no indication that insureds would reject uninsured motorist coverage for antique and collector vehicles if the insurers had to offer uninsured motorist coverage consistent with the statute. That was all kind of supposition and conjecture, and more appropriate for a legislative determination based on legislative hearings and submissions as to what would the effect be if the legislature were to carve out an exception for these types of policies from the typical uninsured motorist law. So we think that the court went beyond just interpreting a statute, and that the court concluded that from policy considerations that really are not substantiated by the record, that there should be an exception. And that
But you look at there is record evidence of the premium in this case for the coverage for the antique automobile. Very low.
yeah, $416.
But the portion itself is 16 in extras?
I think the premium for the was $416, if I'm not mistaken. But that's,
Significantly, I'm going to find the number here, but it was I was impressed by how low the coverage was for this vehicle, which compared to others, which does give some, I think, rationale that the policy concerns of increasing premiums could be legitimate, if you infer based on how low these premiums were.
But the philosophy of the uninsured motorist statute and the decisional law is that that's a decision for the insured, that the insured factors into their decision the cost of the insurance, and the insurer would say, okay, if you want certain coverage, here's how much it would cost. If you want a limited uninsured motorist coverage, here's how much that would cost. And ultimately, the insured makes the decision. I think.
And I'm just because the total premium was $416. I think my information was $58 of that applied to the stacked coverage. Okay, so that was the number I was looking at, the $58, which I do believe to be low compared to a non-antique automobile.
Right. Okay. And there again, it may be that the insured would have accepted, approved of that. But in this case, the insured had no input into the decision, which is the whole focus of the uninsured motorist statute and decisional law, is that the insured makes the decision based on the information provided by the insurer. And it seems that the decision in Martin just skips that analysis and says, well, the cost of uninsured motorist coverage is going to go up and insureds they'll reject it. Well, give the insured that opportunity to decide what level of uninsured motorist coverage they want. That's the philosophy of 627-727. And the decisional law is that the insurer doesn't make the decision, as the insurer did in this case. The insured makes the decision. And so we think that Martin missed the boat on that and focused instead on the effect on the insurer instead of what is the effect on the insured and what does the statute require. And the statute requires the insured make the call. And the insured in this case had no opportunity. They were never given the information. They were never given the options as to what type of coverage was available. They were simply told, here's the coverage you have. And that's contrary to the uninsured motorist statute. So that's why we think that essentially, I think it's kind of how it boils down to. Martin just omitted that crucial factor. And that's the factor that underlies uninsured motorist coverage in this state. So we think that Martin was wrongly decided and that this court has the opportunity to consider whether or not it wishes to follow Martin or whether it wishes to correct what appears to be, in our opinion, an erroneous decision. We'd also just point out that on the legislative or legislating from the bench argument that we raised, there was an argument that, well, this is 20 years, and in 20 years the legislature has never revisited or never visited this issue. Well, we point out that research shows there's only one other case in Florida, and that was a case out of the first DCA, the Whitemore case, appellate case that appears to have addressed this issue. That was a per curiam affirmance based on the Martin decision. So this hasn't come up very often. We think it's entirely speculative and conjectural to say that, well, the legislature somehow approved Martin because the legislature hasn't statutorily overruled it. We think had Martin gone the other way, the insurance lobby probably would have gone to the legislature and looked for some relief to create some exemptions. But surely the insurance lobby wasn't going to go to the legislature and ask the legislature to disturb the Martin decision. So we just think it's conjectural and speculative to think that somehow the legislature approved Martin. Also,
Counsel, regardless, this court has not decided the issue. Is that correct?
Correct. We'd also point out that if in fact this was legislating from the bench, this was exercising legislative powers and not judicial powers, as we've argued in our brief, that this is a violation of Article 2, Section 3 of the Florida Constitution, separation of powers. Each branch of government exercises only those powers that pertain to that branch. And if the Martin court essentially created or legislated from the bench in creating this new exemption for collector antique cars, then we would argue that even if the legislature hasn't acted, that the legislature cannot, by inaction, ratify a violation of that constitutional provision. We think that in a proper case, the judiciary can make decisions based on public policy, but in this case and in Martin, no record evidence to support claims of massive increases in premiums, wholesale rejections of uninsured motorist coverage if insureds are given the option to decide what level of coverage they want. There's nothing like that in the record, and so we think Martin went beyond record evidence. There's no record evidence in here, and there again, we think that's an appropriate matter for the legislature to consider.
All right, thank you, sir.
May it please the court, counsel. Andrew Grixby on behalf of the appellee. Let me just say that counsel starts from a false premise when he's to say is that, well, this is required by the statute. As pointed out in the Martin court, What we're talking about here is extending coverage beyond the insured vehicle. That is not required by the statute. That's required by Mullis. So we're already talking public policy. We're already pregnant. We're not talking about starting legislation. We're talking about an interpretation of the Mullis case. So just to start out with a couple of things. First of all, yes. Obviously, the Martin case is right on point with this. Number two is that there's no argument that there's an ambiguity here in the policy. You've got a clear policy, and it's not a statutory mandate. What Mullis did, and you can take a look at that statute forever, the key language of Mullis and what has been used and imposed on coverage ever since is this Class 1, Class 2 distinction. Nowhere in the statute will you see a Class 1, Class 2 distinction. You will not see anywhere where it talks about Class 1 having this coverage anywhere, everywhere. It's not part of the statute. Nor do you see about number 2s not being able to stack the coverage. So that's a restriction that is not in statute. Even things like, for example, the written requirements in the statute.
Do you agree that an insurer can only limit uninsured motorist coverage if they comply with the statutory mandated requirement of notice to the insured?
Okay. Well, even that's been modified by the courts as well, because when it talks about the written form.
Is the answer to that no? You don't agree with that?
It's yes, in the sense that it can be modified also by a informed oral consent. But what was applied here.
That's not being argued in this case.
No, it's not. But what is being argued here, and is consistent with Judge Altenburn's opinion, was that the statute itself doesn't apply to this type of situation. It's just Mullis, and that
where does the statute exclude antique vehicles?
There is not an exception for an antique vehicle in there. The point being is that in interpreting in a statute, you try to avoid an absurd result, and I think that's what the Martin court, when their decision was, by going through the criteria of an antique vehicle policy, that it would reach an absurd result to impose the Mullis or enhancements that applied solely because of the financial responsibility law at the time, applied solely because you're talking a general use vehicle. In fact, for this particular policy to get it, you have to already have a general use vehicle. You already have to have a policy that is consistent and has the requirements.
Exception for self-insured vehicles.
I'm sorry?
For a self-insured vehicle, I'm talking about the Young case, okay?
Yes,
Supreme
yes.
Court. We have a self-insured vehicle that the Supreme Court ultimately said qualifies as an underinsured vehicle.
I understand.
That would require written rejection of coverage.
Right.
Is that rationale not similar to what we have here? There's no specific exception for a publicly owned, or I'm sorry, a self-insured vehicle in 627.
No, because once again, you're talking about a general use vehicle that doesn't have all these restrictions and limitations. It's not a hobby. That vehicle is being used in the general public. The exposures are the same, and the courts saw no distinction under Mullis to allow any type of exception for that, and show the same rules should apply.
In that case, the insurance company dealt with the issue of self-insured vehicle with a policy exclusion rather than a written rejection, just like we did here. Is that the intent of 627, again, to allow the insurance company to decide what exceptions we have, rather than the legislature?
Well, I would distinguish this once again. You're talking a very small collector car community type policy that doesn't apply for general use. And in fact, like I said, you have to have a policy that is for general use in order to even get this one. And when you take a look at the community,
but that distinction that's not what the statute says. 627, says no motor vehicle liability insurance policy shall be delivered or issued for delivery in the state unless uninsured motor vehicle coverage is provided therein. And then it goes on from there. So they're not making that distinction within the statute. And it seems that if the legislature wanted to make that distinction, they could have done so.
We're providing uninsured motorist coverage. That's not the issue. It's in the policy. It's just this restriction, which comes from Mullis, about whether or not it applies to the insured vehicle or goes beyond that to a third-party vehicle.
Doesn't 9D, tell me why 9D doesn't address this very situation. Explain it to me.
Because the other vehicle is not within the scope of the policy.
Well, look at 9D. Why is that not applicable to this situation?
I don't believe, because the particular coverage is restricted to the automobile, the collector car automobile that's listed on the policy, and I don't think you can extend it. But in any case, as counsel said, and we're not arguing that we got an exception for subsection 9, but the Martin Court...
9D applies, then it demonstrates the legislature actually thought about this very situation. And so I'm asking you, had you gotten written consent, as subsection 9 requires, why doesn't 9D apply here? I mean, there may be a valid reason. I'm just trying to get an answer for why it doesn't apply.
Let's see if I got that language here.
The uninsured motorist coverage provided by the policy does not apply to the named insured or family members residing in the household who are injured while occupying any vehicle owned by the insured for which uninsured motorist coverage was not purchased.
Okay. Frankly, I can't think of a reason why it would not apply right at the moment. Although I do know in the Martin decision, they looked at subsection 9 and specifically said that the collector car policy restrictions are more stringent than what is allowed by subsection 9, and that's one of the reasons why they didn't look to that. But
I mean, it seems to me, it certainly looks like it would apply, except for in this case, your client didn't get the written consent as the statute requires.
Well, certainly the motorcycle that he was driving was owned by him at the time of the accident.
It wasn't?
It was, I believe.
It was. So if 9D applies to this factual scenario, and the only reason that you're not raising is because you didn't get the written consent, I mean, doesn't that demonstrate the legislature thought of this very situation and provided a remedy?
Well, that was part of the statute well prior to, I'll be going back well prior to the 21 years that Martin has been out there. So it's not like it's a reaction to this situation. But I think that what the Martin case was really talking about, and I think what is applicable here is the specific nature of the collector car policy and the restrictions that are placed upon it.
Well, I think Martin said 9D didn't apply, and you're right, it did say that. But my recollection is that they didn't really give him any analysis as to why they thought it didn't apply.
There's not a specific analysis about that. No, they make that statement and then move on to the other factors.
So they might have concluded subsection 9 didn't apply because there was no written consent.
With all due respect, I think the way they say it in there, I don't think that's the case. What they specifically say that the exceptions in subsection 9 are not as broad as what was required by the collector car policy, and so therefore would not allow this even if you had the written consent. As far as this part about the legislature not acting in the 21 years, I think that is a legitimate argument here. I think the court can take judicial notice, if nothing else, that the Florida legislature has shown a distinct tendency to do things like that. I think of the Essex decision that where the Supreme Court decided to apply the provisions of Chapter 627 to surplus lines carriers. I think that was overruled within less than a year, and certainly.
No, but the legislature, tends to react a lot more with Florida Supreme Court decisions than they do with the District Court of Appeal. I don't know that that's persuasive.
Okay. But in any case, it's been out there, and it's one that affects a distinct segment of our population. Counsel says that, well, it's for the benefit of the insurer. No, it's for the benefit of the hobbyists that are involved in this, and don't have to incur the added expense for their hobby vehicles of a full Mullis-type policy when they're already doing that. You're really duplicating or mandating a duplication of coverage that is really not necessary and
I
is
think
not
that's the
consistent
question.
with the
Are you
public policy.
mandating it, right? I mean, or did the legislature simply mandate that you get written consent under 9D? And I know that your argument is that Martin says that it's not applicable, at least in that case, but there really isn't much analysis for that statement. And so I'll ask you, I mean, it sounds like you're not sure why 9D wouldn't apply, other than we don't have written consent in this case.
Assuming that the motorcycle was in fact owned by the person, and frankly, I don't know whether the record answers that question or not. The type of factors that were looked at by the court in the Martin decision specifically were, first of all, the premium as was discussed here earlier, but second of all, the hobby nature of this particular vehicle. This is not the general family use vehicle envisioned by Mullis, and as I've noted, the requirement that the user of this thing actually have a separate automobile that has insurance coverage that meets the Mullis requirement. So there's really no additional interest or concern that is added by applying this statute to the absurd result of putting it on a vehicle that is required to drive less than 1,000 miles, can only be used for pleasure use, and the coverage only extends to that particular vehicle. So based on that, and the unique community that it is operating in, it's quite clear, the policy language is clear on this. There's cover letters that go out with them. This is something, Mr. Lentini had this policy for 8 years. There's no surprises here. And so we believe that the Martin decision is consistent with Florida public policy. It's not required by the statute to do otherwise, and this court should affirm the decision below. Thank you.
Thank you, Mr. Grigsby.
May it please the court. There's several decisions we cite in the brief. Mullis, Coleman is another Florida Supreme Court decision that stand for the proposition that uninsured motorist coverage follows the person, it doesn't follow the vehicle. So that if a person is injured as a pedestrian, if a person is injured in another vehicle, the uninsured motorist coverage follows the person. So that element or principle has been established in Florida for a long, long time. 9D was not raised in this case, the possible application of 9D. I don't see where that was raised in this case.
Well, it wasn't raised because there wasn't written consent.
Well, that could very well be.
I'm just simply asking, had there been written consent, why would 9D not operate here? That was the only question.
Also, the statement that, well, Mr. Lentini had this insurance coverage for something like 6 or 7 or 8 years. We have no indication, the record doesn't show, and the appellee obtained summary judgment, without any proving or indication that Mr. Lentini was aware of his options. This was the policy that was provided to Mr. Lentini. There's absolutely no indication that he was ever informed that there are other options available. It's up to you to choose them. If you choose an option with a more extensive uninsured motorist, your premium's going to be more, higher. And, but it's your call. You make the decision. So yes, Mr. Lentini had this policy, but there's absolutely no indication that he knew what his options were. And so there again, that's what the statute dictates, that it's the insured, not the insurer, who makes the decision. And in this case, Mr. Lentini never was provided with the information, never had the opportunity to decide the scope of the uninsured motorist coverage. We think that's a clear violation of the statute, as well as the decisional law that we cite in our brief, including Florida Supreme Court decisions.
Thank you, sir.
Thank you.
Well-argued case.